All right, the board will call case number 68536 in the matter of Landon Stephon Keating.
Madam Chair, as Mr. Westcott set up, can I get a little bit of clarification on the board's ruling on the plea of jurisdiction? I'm asking so I know what to argue going forward. Does that mean the board has determined that Mr. Keating's offense is a crime of moral turpitude, or would you still like me to argue that?
We have not made that decision. We've just decided that it's not a jurisdictional matter. It's a matter of the merits.
Thank you very much.
Madam Chair, take me just a minute to get set up.
You bet. Does the board need a break? All right. All right, thank you. Before we begin, I'd like to make a couple of housekeeping announcements. I'll remind everybody that this is a compulsory discipline matter, which is an evidentiary matter, so any exhibits need to be offered into evidence and the witnesses need to be sworn. There were some exhibits that were admitted in the prior hearing, but then those were withdrawn. So I'll just remind both sides that we're starting from scratch as far as exhibits, and everything needs to be re-offered.
Actually, I think that's in the Evans matter. This has not had a prior hearing.
Sorry, you're right. Scratch that. I'll say it again when we get to Evans. All right, thank you. Thank you for that clarification. All right, then, Ms. Cates, did you have a brief opening remark?
Actually, more than an opening, I had asked if I, Madam Chair, could go ahead and make my argument for the record on the plea of jurisdiction, and I think that would precede any other statement by the state, because this is a jurisdictional matter. And so I would like for the record at least to make my argument. I understand the ruling of the board, but I would like to make my argument and ask for reconsideration of that issue.
You may do so, but let's just combine that with the rest of your presentation. The court has already, or the board has given that a lot of consideration and has denied it. So let's go ahead and start with Ms. Cates' presentation, and then when it's your turn, you can address the plea or do it.
I have that, and I also have the 51.014 motion, and then a follow-up would be a motion for continuance based on the denial of those two things, and I can do that during my time.
Okay.
Thank you.
Thank you.
I would ask the board, I don't need to make an opening statement. I can go straight into my presentation if you would prefer, but if Mr. West would like to make an opening statement, a true opening statement, then I would defer to him.
Why don't you go ahead and do your presentation, and then we'll let Mr. West do his opening and make his motions and go from there.
Thank you very much. May it please the board. This compulsory discipline matter is based on Respondent's 5 separate convictions of felony level -S, offense of invasive visual recording, bath dress room, wherein Respondent was placed on deferred adjudication community supervision for 5 years. Petitioner filed the instant petition on November 15th, 2023. Respondent's counsel received and accepted service on behalf of Respondent of the petition on November 15th, 2023 via email. Proof of service has been on file since January 3rd, 2024. I know that all of you have read the briefing in this case, so if at any point I'm telling you things you already know about and would like me to move on or start questioning, I am happy to respond to all of those at any point in time. On or about February 26th, 2021, Respondent was charged by 5 separate indictments alleging 5 separate instances of invasive visual recording in cause numbers 1692087, 1692088, 1692089, 1692090, and 1692091, all styled the State of Texas versus Landon Stephon Keating, and all filed in the 208th Judicial District Court of Harris County. On April 4th, 2023, 5 separate orders of deferred adjudication were filed in all of those matters under the same style. At this time, I'd like to offer the following exhibits, and I will pause as I assume Mr. West will be making a few objections.
All right.
I'll go through them one by one. Exhibits 1 through 5 are certified copies of the indictment in all 5 of the previously mentioned cases. And I would offer those at this time.
Mr. West, any objections?
Would you indicate that again?
Yes, sir, 1 through 5, which are the indictments in all 5 of the matters.
No objection.
Exhibits 1 through 5 are admitted.
6 through 10 are certified copies of the orders of adjudication in all 5 of the underlying criminal matters.
Mr. West?
No objection, Madam Chair.
Exhibits 6 through 10 are admitted.
Thank you. The original certificate is Exhibit 12, original certificate from Blake A. Hawthorne, Clerk of the Supreme Court of Texas, dated January 3rd, 2024, indicating that respondent is currently authorized to practice law in Texas.
Mr. West?
No objection.
Exhibit 12 is admitted. Did you have an Exhibit 11, Ms. Cates?
Yes. Thank you for asking. Exhibit 11 is my original affidavit attesting to the fact that respondent is the same person as the person identified as the defendant in the underlying criminal matters.
Mr. West?
No objection.
Exhibit 11 is admitted.
1 second. May I approach to give those? Those are all of my exhibits at this time.
Yes.
May I reserve the rest of my arguments for rebuttal after Mr. West puts on his presentation? Or would you rather hear them now?
I believe you need to meet your burden of proof at least to put the burden on Mr. West to respond.
Thank you. And again, I apologize. I'm trying to make sure I'm not wasting or taking too much of the court's time.
And we appreciate that.
Okay. The commission has met their burden in this matter by filing a certified copy of the final order in the 5 underlying criminal matters against Mr. Keating. In Mr. West's briefing, he has asserted that he does not believe that the crimes that Mr. Keating pled to constitute crimes of moral turpitude, thereby meeting the requirement of the crime to be a serious and intentional crime. Interestingly, perhaps, this is not, to the best of what I can tell.
Ms. Henson, I apologize for interrupting, but it sounds as though she is making a final argument. And there's a time for final argument after we've had the opportunity to present our case.
Thank you. I'll let her make a brief opening statement, and then we'll address your arguments at a later time. Thank you.
There are not many instances that I have been able to find a record of, period, of invasive visual recording. It certainly hasn't come up in any disciplinary case in any jurisdiction that I can find. So the court is truly deciding something of first impression today with determining whether or not invasive visual recording with the rest of the crime penal statute is a crime of moral turpitude. We've argued in our briefing that the court is required to look at the elements of the crime and solely the elements of the crime to determine whether or not they believe the crime is a crime of moral turpitude. The elements of the crime in this particular case not only require intent, it says specifically in the penal code statute that it requires intent, and then it also requires that the person who was being recorded didn't know about it. I've argued in my briefing that that lack of consent is tantamount to a deceptive action. I understand that by the dictionary terms of lack of consent and the word deceit, they are not inherently the same. But in the context of the actual penal code and the words written in the statute, you have to have been deceptive to be able to record this person. It literally requires that the person didn't know that you were doing it and was in a place where they had a reasonable expectation of privacy. Therefore, in this particular instance, and because of the words written, it is tantamount to deceit. It wouldn't be not deceitful if you told the person you were going to record them. Then he wouldn't have been convicted of the issue. I've also argued that the case law allows aggravating factors in so much that if it's a pattern or if it is a habit, you've got 5 separate pleas to a felony conviction of this same crime. It happened over a span of time. It wasn't a one-time instance. All of those matters combined is why we believe, and the court should find, that the crimes that Mr. Keating has pled to are crimes of moral turpitude, thereby subject to compulsory discipline, and therefore by filing the certified copy of the final order of conviction, the commission has met their discipline and Mr. Keating should be disbarred.
Thank you.
Thank you.
Mr. West, you may proceed.
Thank you, Madam Chair. I'm glad that the commission has conceded this is a case involving first impression. That's the very reason I filed a plea to the jurisdiction. You know, I was on BOTA at the time that the Locke case was decided.
I'm sorry, I didn't hear that.
I was on BOTA at the time that the Locke case was decided, and we got it wrong. We didn't have the guidance that the Supreme Court and Justice Hankinson gave us in Locke when it was decided in 2001, and it is still the law. It has not been set aside, it has not been modified, it has not been amended. The reason that this is such an important issue is that if this board, if BOTA doesn't have an intentional crime to proceed on, you don't have jurisdiction to do anything to my client. So that was the crossroads that we arrived at as we decided how to respond to these issues. Now,
are you saying that this board doesn't have the legal authority to determine whether, to look at the statute and consider whether or not the statute has an intent requirement and invokes the body's jurisdiction?
Judge Goodwin,
I'm sorry.
This
Authority to act later?
This board has the ability to get it wrong, just like BOTA did back in the old days in another century. We got it wrong, and I don't want you all to get it wrong because you have
Who cares about old BOTA stuff? People barely care about what we do here. Let's talk about this.
Well,
I'm getting there.
but is that the merits of whether or not the statute, the statutory requirements are met, or are you challenging? I always thought a plea to the jurisdiction attacked the body authority to act.
Well, it is.
Not to get it wrong, right or wrong.
Yeah. We are attacking your ability to proceed on the claim that has been brought by the commission. Now, I'm not arguing that the commission could bring another claim under the disciplinary rules of professional conduct. They could do that, but they haven't. They've arrived here with the wrong vehicle to do something to my client. And I believe that if this board has already ruled that you do have jurisdiction and that you can proceed on that, And that's why I wanted to make my record on this, to take it up to the Supreme Court, so that they can look and determine whether Locke in fact does apply, and Modus should not have taken this case, or it should have. So that's the purpose of the plea to the jurisdiction. Now, in order to be able to establish my record, the reason that we filed this plea to the jurisdiction to enter compulsory discipline against the respondent is because it's based on allegations that the respondent committed an intentional crime because he pled guilty to the felony offense of invasive visual recording under 21.15 of the Texas Penal Code. However, we believe that invasive visual recording is not an intentional crime, as that term is defined by 106V of the Texas Rules of Disciplinary Procedure. Now,
And Mr. West, to be clear for the record, we were discussing this with Ms. Cates while you were getting set up, so I want to make sure you're clear that we have not ruled yet on whether it is an intentional and serious crime. We're just ruling that it's a merits issue, not a jurisdictional issue.
I understand, and I just differ that it is a jurisdictional issue. Not only certainly you can look at it as a merits issue, but I believe it's a jurisdictional issue because if it is neither an intentional crime as defined with a serious crime, then it has no business coming before this body.
Then how would we proceed on, if you're right, oh, I see, that would be dispositive and we wouldn't get to reach your question of a permissive appeal.
Correct.
Got it.
Yes. So, we know that if you look at the elements of the plea to the invasive visual recording, it is not a crime involving moral turpitude per se. And you have to look at Locke, and Locke says the court must look solely to the elements of the crime and not to any collateral matters, such as an attorney's record of service and achievement, or to the underlying facts of the criminal case. Now, and that's a quote from Locke. The comments to Rule 804 of the American Bar Association's model rule say this: although a lawyer is personally answerable to the entire criminal law, we don't object to that, a lawyer should be professionally answerable only for offenses that indicate lack of those characteristics relevant to the law practice. So, in keeping with the court's analysis in Locke, the board must first look to the following elements of invasive visual recording. Now, these are those elements. A person commits an offense if, without the other person's consent and with the intent to invade the privacy of another person, the person photographs or by videotape or other electronic means records, broadcasts, or transmits a visual image of an intimate area of another person if the other person has a reasonable expectation that the intimate area is not subject to public view. Two, photograph or by videotape or other electronic means records, broadcasts, or transmits a visual image of another in a bathroom or changing room. Or three, knowing the character and content of the photograph, recording, broadcast, or transmission promotes a photograph, recording, broadcast, or transmission described by subdivisions 1 or 2. All right, these elements of invasive visual recording do not involve dishonesty, fraud, deceit, misrepresentation, deliberate violence, or reflect adversely on an attorney's honesty or trustworthiness. And as such, in order for an invasive visual recording to fall within the definition of an intentional crime, it must reflect adversely on an attorney's fitness inherently and categorically. Importantly, this is not a question about whether a respondent's crime reflects adversely on his fitness as an attorney. Although,
Mr. West, is it your contention that video recording someone without their consent and with the intent to invade their privacy does not implicate deceit or a person's
Correct.
honesty and trustworthiness?
correct. If you'll give me just a little bit of time, I'll show you exactly why.
Okay.
Although the crime may reflect adversely on some attorneys, some attorney's fitness. It does not reflect adversely on every attorney's fitness. As the court in Locke noted, without looking into the facts of the respondent's particular crime, which BOTA cannot do and is expressly prohibited from doing, it's impossible to know whether respondent's charge of invasive visual recording represents a persistent inability to discharge or unreliably carry out significant obligations. Other criminal offenses have been determined not to be crimes of moral turpitude, including aggravated assault, criminal trespass, criminal mischief, issuance of a bad check, misprision of a felony, and under law, of felony drug possession. Now, I have a chart of crimes that have been so found that I would like to present to the board, and my associate, Ms. Kelch, will present that to Ms. Hodgkins for her distribution, if you would allow that.
Any objection?
Did you send this to me, Gates?
No, I just put it together. And it's simply a demonstrable exhibit.
Can I see it?
Is it an exhibit or a demonstrable?
Yes, let Ms. Cates take a look at it, and then we'll see if she has any objection. Does it capture information that was included in your briefing?
Yes, it's a summary of cases, just a brief.
There's far more on this list than was in the briefing, and and it's all cases, so I haven't had a chance to look at any of them or make sure that the information is correct. So I have an objection because I have no way to verify any of this information right this moment.
I'll represent to the court that all this is a summary of cases that have found the issue of whether there is a intentional crime involved. And I think it would be helpful to supplement my briefing.
Was there a briefing deadline in this case?
Yes.
Yes, there was, but these are cases, and they are simply, most of these cases were cited in my brief. A few weren't because we found them later.
The board will review the demonstrative, but this really is something that should have been included in your briefing. I think it's an
understand.
unfair surprise to Ms. Cates.
I understand. Go ahead.
Can I keep this copy, Gates?
Yes. This chart that will be passed out depicts crimes that have been found to involve moral turpitude and crimes that do not involve moral turpitude. Notably, within this context of attorney discipline, the purchase of a child and tax evasion are crimes involving moral turpitude. Misprision of a felony and felony drug possession are not crimes involving moral turpitude. In Ms. Cates' response to our respondent's plea, she argued without citing any sport, because there isn't any sport for it, she so represented to the board, quote, if you are committing a crime without a person's consent, you are guilty of a deceitful action. That was in her brief at page 9. However, lack of consent does not equate to deceit. This point is reinforced by case law finding that criminal trespass and criminal mischief are not crimes involving moral turpitude, despite the fact that the elements of both these crimes require lack of consent. Accordingly, if you look to the elements of invasive visual recording as is required, the board cannot find that it inherently represents that an attorney is unfit to practice law. It's also important to note that this narrow level of review is limited to compulsory discipline proceedings. There's nothing stopping petitioner from initiating disciplinary proceedings against respondent by compulsory discipline, but compulsory discipline, rather, is not an appropriate route. And the board should grant respondent's plea to the jurisdiction. Now,
Mr. West, was in re GMP cited in your brief?
I don't recall.
Okay. And in re GMP, that is sexual assault of a child is a crime of moral turpitude, correct?
It is.
And I'm
NRA
looking at the
GMP
chart
is.
that you handed us a few moments ago.
Yes.
And it appears, I haven't read the case, but it appears from the chart that you have that the reasoning of the 14th Court of Appeals was it's a crime of moral turpitude because it concerns personal morality. Is that correct?
That is correct.
That's what the case says? It's against good morals. That's what the case says?
That is what the case said.
Okay. An act of baseness, vileness, and depravity. That's what the case says?
That is what the case said.
And is immoral in itself and shows a moral indifference to the opinion of respectable members of the community. That's what the case says itself.
Sexual assault of a child, yes, it does.
Sexual assault of a child does. Okay. And this is in itself, this is a sex crime that we're dealing with here.
It
that
is,
correct?
but it is a different crime. It is not a sex crime because it's not identified as such. You have to only look at the elements, Mr. Iglesias, and that's what Locke tells you. And you have to be able to find that every attorney, every situation would result in a per se violation, and that's what Locke stood for. That's why Boda got it wrong when we looked at it before and then went to the Supreme Court and Justice Hankinson straightened us out. And it hadn't changed since then.
So, and I know that you said you were getting to this. What are the specific facts of this case that are different, which would tell us that not every attorney, and I'd like to use your wording that you just said, every attorney in every situation, and could you fill me in there?
No, I can't,
That you just-
and we can't review every fact situation, and that's the specific holding in Locke, is that you have to look to the elements, and you have to look at those elements and evaluate them, because we thought at the time, when we were looking at whether mere possession of cocaine being a felony, whether that reflected on the fitness of a lawyer, that surely it did.
Should there be any distinguishing between a case like Locke where it was possession of a narcotic substance versus a case like here where there was obviously a victim who was harmed?
Well, I mean, there's a victim harmed, Mr. Iglesias, in the mere possession of cocaine as well. I think that's slicing the bread a little bit thin to say
You
there's
think
no
it's
victim.
slicing the bread thin to say that the victim who was recorded without her knowledge while toileting is different than the victim in a possession of narcotics case?
What I can tell you is that if we look at the elements of this crime, it is clearly not a crime involving moral turpitude, and it lines up with other such crimes that were found to be not involving moral turpitude. And I think that's what Locke says, and that's what Locke admonishes you to do. It
What
may
other-
be that the Supreme Court will
What other
disagree.
sex crimes
What other sex crimes are
have been
not
found
crimes
not to have
involving
moral
moral turpitude?
turpitude?
Yeah.
Well, if you look over on that second page, misdemeanor assaults generally
Not a sex crime.
can be involved in a sex crime. You can have a felony drug possession can involve a sex crime, but you're equating this with a sex crime, and that's not what this is.
Well, Mr. West,
Well, okay,
This
so then
has-
let's just talk about the language of the statute. The bare language of the statute says a person commits an offense without the other person's consent, with the intent to invade the privacy, there's one. And then under paragraph 1, if that person has a reasonable expectation that the intimate area is not subject to public view. Just on those intent to invade the privacy and with the reasonable expectation that the intimate area is not subject to public view. How does that not invoke the standard of it shows a moral indifference to the opinion of respectable members of a community?
I think one of the problems, Judge Goodwin, is that you'll have to make the decision that every case that comes before you on an invasion like this, pled under this case, will always be a crime involving moral turpitude. And there is no case law that supports that. There is no provision. This is
It's a case of first impression.
yes,
Agreed.
yes, it is.
Agreed.
And lack of consent, we know, is not the gravamen to determine whether this is a crime of moral turpitude. And if you look at the elements, not casting specific facts along with those, you will conclude, and should conclude, as the Locke Court concluded, that this is not a crime involving moral turpitude. The
You have to
legislature could have identified it as a crime involving moral turpitude.
You have to have both with intent to invade the privacy and subjectively, the person has to have a reasonable expectation that the intimate area is not subject to public view. Under those circumstances, B and then 1, you have to have both of those elements before you can, with others admittedly, but you have to have those two elements before you can convict of the offense, not getting into the underlying facts of anything. How is that not
A crime
a
involving
good
moral turpitude.
morals? Yeah, good morals, showing moral indifference to the opinion of respectable members of the community. The reasonable expectation that the intimate area is not subject to public view.
I think if the legislature had intended for it to be a crime involving moral turpitude, we know they could have done that. They did not do that.
You know,
That is the statute.
let me add to what you're saying, Judge. If somebody's going around doing invasive visual recordings of arms or bald heads or something of that nature, that's not,
I won't take exception to that, Your Honor.
that's not moral turpitude. But they specified intimate areas. Don't you think that the fact that they specified intimate areas makes this a crime of moral turpitude?
What is the definition of an intimate area, Your Honor? You don't know and I don't know that. And the legislature
Well, I mean,
could
it's
have
in
made
the,
that, pardon me, Your Honor.
statute. An intimate area means the naked or clothed genitals, pubic area, anus, buttocks, or female breast of a person.
What I'm saying, Your Honor, is that if the legislature had intended this to be a crime for involving
They
moral
didn't
turpitude.
use the words moral turpitude, but they specified that this is only for recording, violation is only for recording intimate areas.
I
Any more
understand.
than they've used the phrase moral turpitude in the sexual assault of a child or purchase of a child.
What I'm saying to you is that the Locke Court has said you have to look at these elements and make an evaluation only on the elements. And based on those elements, then if you make this decision in this case, then you're going to make that decision in every case that comes before you involving this in the future. And I don't believe the Locke Court is going to allow this board to do that, like it didn't allow my board to do that.
Mr.
And-
West, if I could ask you,
Yes, Mr.
how
West.
is this not a crime of moral turpitude if he was ordered as conditions of probation to report to the sex offender unit within 24 hours, to participate in sex offender treatment beginning immediately, participate in the sex offender caseload beginning immediately, and participate in sex offender treatment? How do you explain those conditions of probation that does not make this a crime of moral turpitude?
Because the court in Locke said the only thing you can look at are the elements, period. You don't get the opportunity to dig down into the sentencing, the crime, or all of the involvement of what made this bad or the other one good. All you're able to do is look at the elements of the offense. And by doing that, then if this board wants to say that every invasive recording case that comes before you will involve moral turpitude, then so be it. But then I'll ask the Supreme Court to tell us whether you were right or wrong.
I think Ms. Gates wants to lodge an objection.
Well, I would like to ask, Mr. West continues to say that you can only look at the elements, you can only look at the statute, but in his own briefing, he writes, as the Texas Supreme Court stated in Locke, this definition of fitness plainly contemplates that some review of particular facts or a course of conduct may be necessary before one can conclude that an attorney should be professionally answerable for a particular offense or pattern of offenses. So,
I believe that only applies to the fitness
That's correct.
element of the thing, so
That's correct.
the board is convinced that we can only look at the elements. And in deciding this question, the board will only look at the elements of the crime. But Mike, I'll circle back to the question I asked you a bit ago, which is it your contention that recording someone without their consent with the intent to invade their privacy, is it your contention that that does not reflect on an attorney's trustworthiness or honesty and does not constitute deceit?
Yes, looking at the elements of the crime only and saying that that would have to apply in every case, yes, I can say that.
Okay. I believe the board understands your arguments on that.
And I would ask for a reconsideration if the board would like to take a recess to do that.
I don't believe we need to do that.
Thank you.
Motion for reconsideration is denied. If you'd like to proceed to the next phase of your argument
Thank you.
regarding the appropriate sanction.
Thank you. Before I get there, there's two other things I would like to have the board consider, and that is I did file a motion with the board prior to this hearing today seeking a 51.014D out of the Civil Practice and Remedies Code, a permissive interlocutory appeal, because of the nature of a finding that it does have jurisdiction. And if the board were to find that he had, in fact, involved himself in a crime involving moral turpitude and found that he, is either disbarred or suspended, then that's going to wreak a real havoc on his life. I heard Judge Goodwin speak of 808 and how that affects, isn't this just trying to wire around it? Not on a plea of jurisdiction basis, and that's why I chose this vehicle. Because on a plea of jurisdiction basis, if, as you have denied my plea, then appropriately, then I should be seeking this 51.014D request for an interlocutory appeal. And the reason why is the order is not otherwise appealable. It involves a controlling question of law as to which there is substantial ground for difference of opinion. We've demonstrated that here today between me and the commission.
Well, isn't that true in every case, that the opposing parties are going to have a difference of opinion? I don't think that meets the standard required.
Well, no, it's not, but what is, it's a controlling question of law. And I think we have that here. And an immediate appeal from the order may materially advance the ultimate termination of litigation, because if the jurisdictional question is decided in my favor, then that would result in the case being dismissed, as it was in the Locke case. So the issue that
Well, not necessarily. What if the court said, what if the Supreme Court says, oh, no, you have jurisdiction to determine this, and then they kick it back for that very determination?
they could. They could kick it back here for that determination.
So then how does it speed things up if we don't just do it all at once?
Well, it speeds things up because there's no reason for my client to have to sit before this board and respond to these issues if, in fact, you shouldn't be hearing these issues. Okay? So based on that request, my request for the interlocutory plea, which would be permissive, I'm also asking for a stay of the proceedings so we can get that determination from the Supreme Court. And I understand you've already denied that. Is that correct?
Yes.
Okay.
To
Then
the
based,
extent you made a motion for reconsideration, that's also denied.
thank you. And then based on my plea to jurisdiction and my 51.04D of the Civil Practice and Remedies Code, I would ask for an emergency motion for continuance. I have an affidavit prepared by me that I would like to present to Ms. Hodgkins for the board's consideration.
Would you let Ms. Cates look at it first, please?
Sure.
This affidavit is based on I guess I don't really have an objection to the affidavit.
Thank you.
Okay, thank you. Is that something you're offering into evidence, or is something you just like the board to consider?
Well, it's what has to come before the trial court as an emergency motion for continuance, because it has to be supported under Rule 251 with an affidavit. And so that's why I am bringing this affidavit. Yes, I'd like you to consider it.
Okay, and
May I present to Ms. Hotchkiss?
yes.
Please do so. Thank you.
And what is the basis for your emergency motion for continuance?
My client seeks the motion pursuant to Rule 251 of the Texas Rules of Procedure. A continuance is justified and necessary for the board to determine the threshold jurisdictional matter at issue in respondent's plea to the jurisdiction. The motion for continuance is made in good faith and not sought for the purposes of delay. And not sought for the purposes of delay.
The motion for continuance is denied. We've addressed this issue in several different forms under different vehicles. You had a motion to bifurcate, I think, and pleaded the jurisdiction. And we've repeatedly and consistently said we're going to consider these matters together and all the issues at once. And so I think you're on notice. It have been for a time that we're going to do this all today.
I understand that, and all I'm saying is that in order for my record to be complete, I have to I'm not trying to aggravate the board or argue with the board. I'm simply trying to make sure that my record is accurate and complete before I take this issue up.
Understood. Thank you.
Okay, thank you. And are you ready for me to go ahead with my case in chief?
Yes. Well, would the board like to take a quick break before we get into the evidence?
I'm fine.
Okay, you may proceed.
All right, thank you. Let me give a brief opening, if I could.
Sure.
Although respondent maintains the board lacks authority to impose compulsory discipline, the board should also deny petitioner's request for the sanction of disbarment against my client. On April the 4th of 2023, the respondent received an order of deferred adjudication. You saw that when the commission put that into evidence. Respondent pleaded guilty to the offense of invasive visual recording. Was placed on deferred adjudication, community supervision for 5 years. He received no conviction. Accordingly, pursuant to Rule 8.06, respondent is an attorney who received probation through deferred adjudication in connection with the board and was determined to be a serious crime. As such, the board has the discretion to decide whether to impose a sanction of suspension or disbarment against my client. Further, the board may consider mitigating factors in its sanctioning decision. Today, you will hear evidence of several mitigating factors that weigh in favor of sanction of suspension. Specifically, the board will hear from the respondent, Mr. Keating himself. He'll testify that he has no disciplinary history. He has fully complied with the terms of his probation. He is deeply remorseful for his conduct, and that the underlying conduct was in no way related to the respondent's legal practice. The board will also hear from respondent's colleagues who are here today to testify that the respondent is a diligent attorney who zealously advocates for his clients, and that respondent is a trusted colleague. Finally, the board will hear from the respondent's family, who will further testify to respondent's character and his desire to rehabilitate. Accordingly, based on the evidence that we will bring of mitigating factors weighing in favor of suspension, respondent requests that the board exercise discretion and enter a sanction against respondent for suspension through the duration of a respondent's probation. I would also ask that this board consider, if it enters an order of suspension, that it be an order that is fully probated order of suspension. That way, the board would have, through the commission, the opportunity to investigate, look at, see if my client is following through with his requirements. He is practicing law, he is doing well. It would give the board the ability to not only immediately disbar him if he fails in his underlying criminal probation, but it would give you the opportunity to look at his actions, and if the commission felt like he was not fulfilling his obligations under the probation, even without the criminal probation being denied or lifted, then you would be able to bring him back in here and talk to him about whether he should be disbarred or actively put on suspension. That's the conclusion of my opening statement.
Okay, you may proceed with putting on your witnesses.
Thank you. I'm going to first call Paul Schiffer.
Mr. Schiffer, the witness chair is there behind the court reporter.
Thank you.
It's a little awkward positioning, but it's hard for us to see witnesses when they're placed elsewhere.
And Madam Chair, if it's all right, I'll ask these questions from here. That way you can see him, and I don't think you need to see me.
Okay, that works. Thank you.
Thank you.
Yes, yes, please.
SCHIFFER.
I do.
Mr. Schiffer, would you state your name for the board?
Good morning, my name is Paul Schiffer.
What do you do, Mr. Schiffer?
I'm an attorney licensed in the state of Texas. This October will be my 49th year of practice.
And what kind of practice do you have?
I have been a criminal defense attorney for the last 44 years. For the first 5 years of my practice, I was an assistant district attorney in Harris County.
Do you know the respondent, Landon Keating?
I do.
How do you know him?
In October of 2020, Landon came to my office after he was arrested and asked me and another attorney, Neil Davis, if we would undertake his representation. We agreed to do that, and I have been his criminal defense attorney since that time.
So you didn't know Mr. Keating before then, that's when you began to know who he was at that time?
That is correct.
And how would you describe for the board Mr. Keating's character and conduct?
Well, I want to say all good things about him. There's not one bad thing I can say about him. I can start from the very beginning and say that my due diligence as his attorney would require me to investigate his case and to look at the visual recordings that were captured and are the evidence in this case. I was specifically instructed by Mr. Keating to do that because he wanted to spare Angela, the individual who was recorded, any further embarrassment by having even his attorney have the opportunity to see what might be on him. I was interested in looking at it, doing my due diligence about whether or not the elements of the offense would be met. And it's not as though Mr. Keating said that they would be, but he specifically instructed me, I don't want you to be looking at that because it wouldn't be fair to Angela. He was immediately remorseful explained to them the nature of my relationship and advised them that while he had this deferred adjudication presently pending, it was my opinion that they would be in good hands with an attorney whose judgment I respected and whose integrity I admired. And I have never been disappointed in making that recommendation or referral to Mr. Keating. I have developed a relationship with him. We speak frequently. We go out to lunch often. My son, who is now licensed for over 4 years, who has developed a personal injury practice, has spoken with Mr. Keating to get his advice. Mr. Keating's a well-spoken, very literate, intelligent individual who is extremely remorseful for what he did. At the time of his plea, when we appeared in court in front of Judge Armstrong in April of 2023 to resolve this matter, it was on the representation of the prosecutor that the complainant in this case did not want to see him convicted, that she wanted him not to have a conviction on his record. As part and parcel of my effort in presenting to the district attorney's office and the judge in the case, those matters that I felt would be informative, I put together a mitigation package which included a letter from the complainant's father, that was extremely.
I'd like to ask the chair if we could conduct this on a question and answer basis rather than narrative.
Yes, that's fair.
Sure, thank you. You said you talked to his father, is that correct?
I believe I spoke with his father, but I secured a letter that I included in this mitigation packet where the father of the complainant asked for mercy. It had been the wishes of the complainant that Mr. Keating seek spiritual counseling, and he accomplished that. And the letter from both the
If you could just answer his question and let him ask you another question, please.
Let me ask you, have you seen steps that Mr. Keating has taken to rebuild his life after this unfortunate incident?
Yes, I have.
Would you describe to the board what you've observed?
One of the requirements of his probation was to attend sex offender counseling. In response to your question, Mr. Vice Chair, in other cases, we'll say where there's been an improper student-teacher relationship with a teacher and an 18-year-old student, which met the elements of the crime, where there was no sex offender registration required, it was still a condition of supervision that an individual, a defendant, who received a deferred get that, just I guess, to be on the safe side. So anytime there was the intimation of something that might connect it sexually, in the interest of safety, shall we say, a person was referred to sex offender counseling. Mr. Keating was, and the court allowed him to continue to see Dr. Joseph McDaniel, PhD, and a licensed sex offender treatment provider, licensed by the state of Texas, who he had sought out prior to any plea.
Excuse me, sorry. Ms. Gates?
I would ask that the witness be instructed to only testify about things that he has direct personal knowledge of. We're just rampantly into hearsay territory. I'm trying really hard to be generous, but please, just anything that he has personal knowledge about, that he had personal conversations with Mr. Keating.
Yes, you are here to testify only about your personal knowledge, not things that people have told you or things that you've read. Ms. Cates, if he veers off of that territory, then just object as it comes.
Thank you.
So what steps specifically did you see or observe Mr. Keating taking after his plea with you?
Spiritual counseling through the Archdiocese of Galveston, Houston, attendance, both individually with Dr. Joseph McDaniel, and then as a requirement of the court's condition of supervision, which he successfully completed.
And did that influence you to be able to continue to have a business relationship with him, referring clients and that sort of thing?
Yes, to a limited extent. I developed my own opinion.
Okay. Now, you're a busy lawyer, but you decided to come today. Tell the board why you decided to come.
While Mr. Keating pled guilty to this offense, I think that the question about whether or not his character is such that he is fit to practice law, it is my opinion from my 3.5 years of a relationship with him as a fellow attorney. I trust his judgment. I believe that female clients are safe with him. I have referred clients to him and have gotten positive feedback. I would trust him to represent myself or a member of my family. I have such a high opinion of his ability.
Thank you. Pass the witness.
I don't have any questions, thank you.
I have a question for you, sir. I have a question for you, sir, if I could, Mr. Schiffer. Did I understand you correctly to say, sir, that Mr. Keating asked you not to view the video of the complainant in this case?
That's correct.
Is that because of the baseness, vileness, and depravity of the crime in this case?
I did not ask him, but I would assume that if there was as alleged, images as reflected in the charging instrument, that Mr. Keating did not want to embarrass the complainant.
Thanks, sir.
I've got a question for you, Mr. Schiff. Mr. Graham here. Have you ever seen the videos at issue?
No,
So you have no idea what they contain?
I have not seen them.
So you don't know if they're really good, really bad, whatever is on them? You've got no knowledge of that personally?
No.
And you've had a professional relationship with Mr. Keating as his defense counsel before. I feel compelled to ask this question. Are you being compensated for your time today?
No.
Thank you.
Mr. Schiffer, where did the recordings take place?
They took place in a suite of offices that Mr. Keating shared with the complainant. She had her business, he had his law office, and it was the restroom in that suite of offices.
The suite of offices that included his law office?
Correct.
And what was the relationship between Mr. Keating and the complainant?
They were friends for years. They were in a short dating relationship, and then the complainant married, had a child, and he was the honorary uncle of the young child.
Did the complainant work for Mr. Keating?
No,
They just had offices on the same floor?
they did, and Mr. Keating represented the complainant and the husband and successfully finished whatever legal work he had with it, even during the pendency of this marriage.
So she was a client at the time that the recordings took place?
To tell you the truth, I am not sure if he was at the time.
Okay, thank you.
I have a question. Do you know what the statutory basis is for the restrictions about possessing firearms in this case?
It's a standard condition, somebody who is when you have a deferred adjudication, you are still under indictment, and federal law prohibits anybody who is under indictment from possessing a firearm or ammunition.
Any other questions?
I thought it was only upon conviction or a plea of certain offenses.
That you couldn't possess?
Correct.
No.
Okay. Thank you.
Any other questions from the board? All right, thank you. You're excused, Mr. Schiffer?
Yes, may he be excused?
Yes.
Thank you.
You may call your next witness.
Thank you very much. I would call Mohammed Abdel Rahman.
Could you spell the last name, please?
Abdel, A-B-D-E-L dash Rahman, R-A-H-M-A-N.
Thank you. Madam Court Reporter, would you please swear in the witness?
Sure, let me just get that name again, spell your entire name.
Mohammed is spelled M-O-H-A-M-M-A-D. Last name is Abdel Rahman. That's A as in apple, B as in boy, D as in dog, E-L, R-A-H, M as in Mary, A as in apple, N as in pencil.
Would you raise your right hand, please? Just almost swear or affirm the testimony you're about to give in the cause before you, be the truth, the whole truth, and nothing but the truth.
Yes, sir.
Thank you.
State your name for the record, if you would, please, sir.
Of course, Mohammed Abdel Rahman.
And where do you work?
I work at Keating, Rudy, and Abdel Rahman, a personal injury law firm in Houston, Texas.
All right, and what type of law practice do you do?
I have done solely personal injury since my licensure.
Would you speak up, please, sir?
Absolutely. I have done solely personal injury since my licensure.
And do you know the respondent, Landon Keating?
I do.
How do you know him?
I met him first year in law school in 2013.
So you've known him since 2013?
That is correct.
And how did you and Mr. Keating meet? Was it at law school?
Yes, we were in the same section together.
And how would you describe, in your estimation, Mr. Keating's character is?
Would you like it at this present moment or before?
Both.
So before, initially when I first met him, I've always thought very highly of him. Him and I would, I'm a very devout Muslim and he's a very devout Catholic. Excuse me. He's a very devout Catholic, and one of the things that, although we disagree on a lot of points in terms of religion, a few things that we all agree on is, the devil always finds its way somehow, some way. God is good, God is always merciful, and there's always a path to redemption.
And that was before. Now how do you see him and
It
his
has not
character?
changed. It has not changed. I've grown to love him. He is one of my best friends. And I've always told my wife, should anything ever happen to me, please contact Landon, and Landon will for sure take care of you throughout the entirety of their lives.
Have you ever referred cases to Mr. Keating?
Absolutely.
And how did you become aware of his criminal matter?
He confided in me shortly after he was arrested.
What was your first impression when you learned about Mr. Keating's criminal matter?
Initially, I didn't know what to think. And so...
Were you surprised?
I was surprised.
Okay. Why?
It's outside of his character. It's outside of his nature.
And then how did you feel after you learned about it?
Again, I was surprised. However, I had a long chat with him, and I didn't want to know the specifics at that time. And we just prayed together. We truly just prayed together and told him that, things happen for a reason. Whether the wisdom of God is apparent at this point or later, there's always, some reason why this happens.
And how did you see him move from that incident to the present day?
It's interesting because he was always a very kind person, always very generous. However, the best way to say it is he's exceptionally remorseful to the fact where he's over generous in having some sort of humbleness that he hasn't had before. And although he has always been humble, I've noticed that he has been a more humble person in allowing himself to be, I don't know what's the best way to say it, but I think he's grown into a better person, and I think because of this, it has truly made him into a better person.
Are you familiar with Mr. Keating's legal practice?
Yes.
And what is it?
It is, before, it was the Keating Law Firm, and he was a full-service civil litigation, as well as he does criminal aspects. And I referred him cases while I was an attorney at another place. Since then, we've formed together a law firm.
Do you think his criminal matter affected his legal practice?
I don't think so.
Why do you say that?
The clients that, clients who have completed their representation with him, I've met them because he maintained friendships with them, and every single one has spoke highly of him. Even the joint clients which I referred have only said great things about him and how sometimes they just don't want to take the call
After news of his criminal matter was out, how was Mr. Keating treated by his clients?
I have not heard of any client who left him because of that. In fact, I had a conversation with him and how he explained to every single client what has happened, and he gave me the option to terminate representation, and as far as I'm aware, none have.
Have you continued to work with Mr. Keating after learning about the criminal matter?
Absolutely.
Do you believe that he's remorseful about his actions?
Absolutely.
Have you seen changes in Mr. Keating since his criminal matter?
Absolutely.
What have you seen?
As previously mentioned, he is doing what he can to rectify and make the people around him better. He's actively trying to make amends with anything or anybody who's ever harmed on this very short list, as well as do steps to better the community around him.
What steps do you believe Mr. Keating's taken to rebuild his life?
He has definitely gone to church a lot more. He has privately, him and I have discussed donations to certain charities, certain funds, in which he has done that. And I've advised him on numerous religious matters, and I always advise him, so long as your intention is to be a better person, you need to do whatever you can so God can have mercy on you.
Did you travel here on your own today?
Yes, I did.
Are you being paid for this?
Absolutely not.
And why did you come?
Landon is, without being a blood relative, he's the closest person I have to a brother. And he is an exceptional person, brilliant person, and one of the best people I've ever met.
Is there anything else about Mr. Keating you'd like to share with the board?
Landon is he's a great person. He truly is. He loves to make jokes. He loves to have fun with us. Him and I and our other partner, Austin, we have been friends since law school. We've maintained friendship throughout this entirety, as well as we do whatever we can in order to do right by our clients. And in anything that Landon has ever needed, or we've needed, we've always reciprocated.
Pass the witness.
Ms. Gates, do you have any questions?
Yes, please. I'm just going to talk as loud as possible.
Why don't you come to the podium so it makes it easier for the board to hear?
All right. Good afternoon, sir. I think we're at afternoon. You said during your questioning by Mr. West that you believe that there's a reason that everything happens, and that you believe that Mr. Keating feels the same way, correct?
I believe so.
Has he told you why he thinks this happened?
From a religious perspective, it's only, we don't understand the divine wisdom, but something God wanted at this particular time occurred for whatever reason. We may not know the truth, or we may not know the answer to that question. We may find out in 5 or 10 years, we may find out tomorrow, but at this time, it's just, whatever the wisdom of God is.
Did you ever ask Mr. Keating why he did this?
I have not.
Why not?
I felt like I could see on his face the anguish, and every time I would try to talk to him about this. However, I always believe that, the devil may come over you and make you do some things that is absolutely outside of your character. And for whatever reason it is, I just do not want to know, or have this perspective on it.
Have you seen the videos?
No, ma'am.
Have you asked to see the videos?
No, ma'am.
Do you think your opinion would change if you saw the videos?
Objection, speculation.
Sustained.
Not having seen the videos and not knowing exactly what was the circumstances that took place that led to it or during the events, do you think that you would feel differently about Mr. Keating if he had recorded your wife in the bathroom?
Same objection, speculation.
Sustained.
You weren't officing with Mr. Keating when the events happened, right?
That's correct.
Do you know the facts surrounding how it happened? Like where the video was being recorded?
I don't.
Okay. No further questions. Thank you.
Thank you. Any questions from the board?
Thank you for coming here. I'm gratified that Mr. Keating has such a good friend in his life, so thank you for coming here.
Thank you. You're excused, thank you. The board's gonna take a brief 10-minute recess. We've been going about an hour, but I know some of that has been board questioning and cross-examination. Do you think we can wrap up in the next 30 minutes once we get back from the break?
Yes, I believe so. I just have another 2 witnesses and then my client.
Okay, thank you. We'll stand in recess until 11:10. Thank you. Thank you. We are back from recess.
Thank you. That was a nice break. I appreciate it.
Mr. Gaines, you may call your next witness, and we really need to wrap this up by 11:40, so I just urge both sides to use their time wisely.
Will we have a lunch break after that, or do you want to, we can go ahead and dispense with the last one if you'd like.
Would prefer to go right
Fine,
through.
fine.
That's okay.
Yes, it is. My next witness will be Austin Rudy.
What was the name, Mr. Gaines?
Austin, Austin, Rudy, Rudy.
Please raise your right hand, please. Solemnly swear to affirm the testimony you have to give in the
Go ahead and take a seat. Would you be sure and keep your voice up, if you would, Mr. Rudy? All right, thank you. To state your name for the record.
Austin Rudy, Rudy.
And where do you work?
I work with Keating Rudy Abdelrahman.
And how long have you known Mr. Keating?
Since 2013, I met in law school, first semester of law school.
Much like we heard Mr. Abdelrahman testify?
Yes, sir.
Then what I want you to do is concentrate on telling Boda your interactions with Mr. Keating and your observations of Mr. Keating. What was he like before this incident occurred?
He's always been very generous. He's always been very caring, thoughtful. One of the most thoughtful people I've ever met. He's been that way since I've first met him, and he's still that way today.
What happened when you learned of the incident?
At first, when he approached me to talk about it, I knew it was a very difficult conversation for him to have. He was very embarrassed, remorseful, regretful, and I believe he continues to be that way today.
You knew his legal work prior to the incident, correct?
Yes.
Is it any different now?
I believe it's been a little bit better with his diligence, his care, his concern. I believe he's one of the most intelligent people I've ever met, regardless of profession.
Well, this wasn't asked of Mr. Abdelrahman. I mean, obviously, you want to see him keep practicing law because it would be in your financial interest to do that, right?
Yes.
So is that why you came here, is to make sure that you kept a good financial future?
No.
Why did you come here then?
He's one of my best friends, and I know he's a very good lawyer, and he's done well by all of his clients.
Were you paid to come here today?
No, I was not.
You came on your own.
I did.
Why did you come on your own?
Because I care about him, and I know the practice of law means, it's one of the things that means the most to him.
And did he talk to you about the incident?
He did.
And what did he say?
He told me what had occurred, that he was charged with the video recording of Angela, who was his ex-girlfriend, but a friend at the time.
And how would you describe Mr. Keating as a lawyer?
I believe he's a brilliant lawyer. I believe his knowledge and ability to understand various aspects of law is amazing.
Why have you continued to work with Mr. Keating after learning about his criminal matter?
I believe he's a good lawyer, as well as I believe everyone can redeem themselves, and everyone has made a mistake in life, and I don't believe that his mistake reflects his character.
You were here when I asked the board to consider putting Mr. Keating on a fully probated suspension. Do you think that would be in his best interest?
I think his best interest would be the ability to practice law with no suspension
Okay.
for him and his clients.
All right. Do you know what steps Mr. Keating has taken to rebuild his life?
I know he's gone to counseling. I know he has been more involved with his faith. I'm not a religious person, but I know he's taken a lot of steps to become closer to God.
Is there anything else about Mr. Keating that you want the board to know?
I believe he is a good person. I believe one mistake doesn't define him as a character, or his character, or as a person, and I believe that he benefits the practice of law by competing.
Thank you. Pass the witness.
Ms. Cates, do you have any questions?
Just a few. Mr. Rudy, have you seen the videos at question here?
I have not.
Did you ask to see the videos?
No, I did not.
Why not?
I don't think I need to see the videos to understand the seriousness of the charges.
How serious do you think the charges are?
Objection. Calls for speculation.
I'm asking in his personal opinion about these particular charges that he, with whatever knowledge he knows about.
Overruled.
The charges of being video recording without someone's knowledge.
Correct.
Yes. The seriousness and the aspect of that he could potentially have gotten jail time.
Okay. Do you know the circumstances surrounding how the recording happened?
Generally speaking, I do.
What do you know?
That he shared an office with Angela, and that they shared a restroom, and the recording device was in the restroom.
Do you know if Mr. Keating met clients in that same office building?
I'm not aware.
Do you know if clients were able to use that public bathroom?
I'm not aware.
No further questions, thank you.
Questions from the board? You're excused, thank you. Mr. West, did you have any follow-up?
No, thank you.
All right, thank you, then you're excused. Call your next witness, please.
Yes, I would call Francis Keating.
Could you spell Francis for me?
Capital F-R-A-N-C-I-S.
Thank you. Would you raise your right hand? Solemnly swear or affirm the testimony you're about to give in the cause before you to be the truth, the whole truth, and nothing but the truth.
I do.
Thank you.
Mr. Keating, now keep your voice up if you would, and please state your name for the record.
Francis Edward Keating.
And Mr. Keating, are you the father of the Mr. Keating that is under inquiry today?
I am.
And could you describe for the board your son briefly?
Conscientious, very critical of me, and wanting to be the best person he can possibly be, in my opinion. I've advised him of all of my mistakes in life, and have told him that in order for me to succeed, I would expect him to be a better man than was I, and I think he's been on that mission.
How did you find out about the criminal incident?
I made contact with Rose. I was called on the telephone by either Sergio or Angela and asked to talk with the family about what had occurred.
And how did you react to finding that this occurred?
I was upset. I wondered what the hell had happened. I went to the house and I talked to them to get a feel of what their thoughts were about what was going on. And my mind was clouded, was full of the thought that I need to talk to my son and try and understand what's happening.
Why did you come today?
Why did I go to them?
Why did you come here today?
I came here because my son has this difficulty before this board, and I love him and want to be supportive of him.
What do you want this board to know about your son?
My son, since this situation, has become even more he's looking at in terms of what this board can do to him.
Thank you. Thank you. I'll pass the witness.
Ms. Bates?
Mr. Keating, my name is Amanda Cates, and I'm here on behalf of the Commission and the State Bar of Texas, and I want to thank you for being the kind of parent that shows up for their child, regardless of the circumstances. I think we need a lot more parents like you, and I appreciate all of your efforts. How do you personally feel about your son committing these acts?
I think that, first, I have tremendous respect for women. I don't like the idea of anyone doing anything that's negative against a female. I've often said, they're God's hands, you're right. So to the extent that this happened, I don't feel very good about it at all. But I don't think that what happened here is a description of who Landon is as a person. I think that this was a blip, very bad, but this is not who the man is. And I can say that because I've been with Landon, taking him to school, homeschooling him, and taking him to school and picking him up, all the way through high school. I know that very, very well. This is outside of this character.
You stated several times that Mr. Keating, your son, is very critical of you. Can you explain what you mean by that?
Well, he's critical of mine. I've been married before. I've had a relationship with his mother. He's been critical of my relationship with his mother as a man. He's been critical of my being a father. He's been critical of my not being the man that I have tried to have him be. And talking about the changes I need to make. And this has become increasingly a part of the conversation since this situation occurred with Angela.
What kind of conversations have those, what does those conversations look like?
When you say what do they look like?
Well, you say increasing conversations since this happened. What kind of conversations?
Well, he simply seems to be more aware of the need to do the right thing. And he looks at me, I've always pointed myself out as an example, and he looks at me now as that example, and is more critical of that example than he has been in the past, and thusly more critical of himself.
Thank you very much for your time and your presence here today. I don't have any other questions. Thank you.
Thank you. Mr. West, do you have any additional questions?
Nothing further.
Anything from the board? All right. Thank you, Mr. Keating. You're excused. You may call your next witness.
Thank you, Landon Keating, please.
This courtroom's not set up for taking evidence, and so it's a little awkward. I apologize.
It isn't, is it?
Would you raise your right hand, please? Solemnly swear to God, and testimony you're about to give in the cause before you, be the truth, the whole truth, and nothing but the truth. Thank you.
Mr. Keating, would you state your name for the record?
Certainly. Landon Keating.
And your involvement in this proceeding is as the respondent, is that correct? Where are you currently living?
In Houston, Texas.
Are you married?
I'm not.
Do you have any children?
No, sir.
Where'd you get your undergraduate degree?
The University of St. Thomas in Houston.
And what other degrees do you have?
I also have a master's degree and a law degree.
And
Mr.
where did you-
Keating, would you speak louder, please? Much louder.
Certainly, excuse me.
Why don't you try that again? Where did you get your undergraduate degree? Speak up.
The University of St. Thomas in Houston, where I studied political science and theology. I have a master's degree in political science and, of course, my law degree.
And where did you get your law degree?
St. Mary's in San Antonio.
And when did you become licensed to practice law?
2017.
What areas of law do you primarily practice in?
Presently, I operate with my partner as a personal injury civil litigation firm. Formerly, I operated a general litigation practice.
When did you decide you wanted to be a lawyer?
I scarcely remember a time when I did not want to be a lawyer. I remember being 4 years old, wanting to be a lawyer.
What do you enjoy most about practicing law?
I enjoy being able to help my clients. My desire to help my clients and to be a force of good in people's lives has been the basis of my aspiration to be a lawyer for a very long time. Indeed, it was defining and dictating even the saint's name in whose name I was confirmed when confirmed years ago. I was confirmed in the name of Saint Deo Gratias, the patron saint of leadership in hard times. I chose that saint because I knew then, as I hadn't known before then, and subsequently that I wanted to be a lawyer, and as a lawyer, I wanted to be a benefit to persons through their choice. So it's good for them.
Now, excluding this discipline matter, have you been the subject of any disciplinary actions before?
I have not.
Now, do you understand what crimes are at issue in this proceeding?
I do.
What are they?
5 counts of evasive visual recording.
And you were criminally charged for invasive visual recording, correct?
Yes, sir.
And what was the outcome of that criminal matter?
I received 5 years deferred adjudication.
I don't need all the details, but can you briefly describe some of the terms of your probation?
Certainly. I am not to leave Harris County and her contiguous counties. I was to engage in counseling. I'm not to own or use or possess firearms or ammunition. And a myriad of other standard probation terms.
Have you adhered to those terms?
I have.
Obviously, you're here today. This is not Harris County. How did you get here today?
I received a dispensation to allow me to come here
Okay.
to sit before this board.
Were you convicted of anything in your criminal matter?
I have not. No, sir.
You've only received deferred adjudication, correct? Okay. Do you feel you were cooperative during your criminal matter?
I was.
When was your order of deferred adjudication entered?
April 2023, last year.
So you finished your first year, is that correct?
Yes, sir.
And how has that gone?
It's going well. I went before my last community supervision meeting just a couple weeks ago, indicating the completion of the 1-year mark and the 20% mark. And we talked about pursuing early termination towards the latter part of this year.
Have you ever had any issues fulfilling the term of your probation?
No, sir.
Have you continued practicing law since your probation began?
Yes, sir.
Do you feel that your criminal matter has interfered with your ability to represent your clients?
No, sir.
It hasn't impacted your ability to practice law, is that correct?
No, sir, it has not.
Do your clients know about your criminal matter?
Yes, they do.
How did they find out about it?
I told many of them. I told all of them who did not find out independently. Only a few found out independently. I called all of them and told them the peril I was facing. Offered them the opportunity to have me withdraw from their case and either surrender my interest in the case or refund to them the retainers that they paid if they paid a retainer. Unfortunately, not a single one of my clients terminated our representation.
Did you receive public feedback on this criminal matter?
I did.
What was it like?
I was excoriated before our bar. Paul Shepard, my criminal attorney, advised that I terminate my Facebook account, expecting excoriation, and that came. The news picked up the fact of my wrongdoing, the fact that I've been charged. There were news stories published about it. Those news stories were heavily commented upon on the Texas Lawyers Facebook group and in other places. And I was excoriated rather extensively for our part.
Was one of your current or former clients a victim?
No, sir.
For the board's understanding then, I know Ms. Cates has asked this of all the witnesses so far, and I'm sure she's going to ask you. Why'd you do it? What did you record? And can you just tell the board what happened?
Certainly. Angela and I, Angela being the sole victim of my wrong conduct, met in 2009, and we developed a very close friendship subsequently. That close friendship blossomed into a romantic one.
Was that a consensual sexual relationship?
Yes, sir, it was.
Okay.
And that ended shortly before I went to law school in 2012. I left and went to law school in San Antonio. Angela got married. I came back. After law school, I commenced my private practice. I did not have an office. I began sharing the office space with Angela and her husband and her father's business, all in this single floor suite of offices we had. Frequently, only Angela and I were left in the office. The front door was locked because nobody came to the office. The office was in an industrial type of complex, which I did not think was suited for receiving clients. I never received any there. And during that time, during those first years of my practice, I missed Angela. I pined for her.
You what?
I missed Angela. I pined
Oh,
for
okay.
her. And in that, I reported her. I placed the recording device, a telephone, in the restroom and reported her toileting.
Why'd you do that?
In part because I was, the why was one that I struggled with even at the time. And it's a why that I've only come to grips with better through the course of counseling and direction and through the course of this odyssey here. There was this longing for her, and there also was this desire to be caught. There was a sense that as my practice was doing well and as I felt I had so many good things in my life that I wasn't deserving of them. And
Well, you got that wish, didn't you?
I sure did. And unfortunately, I'm here, facing the peril of losing the thing I thought to attain and most cherished on my law license.
Were you experiencing any chemical dependency during this time?
I was not.
Were you experiencing any mental disability during this time period?
I was not.
How would you describe your emotional state during the time in question?
Perhaps lonely. Perhaps lonely.
Since you were placed on probation, deferred adjudication, what have you done to rebuild your life?
I have pursued counseling, spiritual direction, hard and painful introspection. I've worked to make myself into a better person, to take the negative of what I did, the pain I caused a person who was my best friend, and all of the trauma that followed, to become a better person for myself and even for my clients, which in a way is one of the things I'm appreciative of. I never would have thought that I would have been a criminal defendant. I never would have thought I would have needed to have hired counsel to represent me in proceedings like this one. I've been able to see excellent lawyering. I've been able to come to better empathize with my own clients, understand where they are, and bring to them a better way.
Are you seeing a
You've got about
psychiatrist?
5 more minutes.
Pardon me?
You've got about 5 more minutes.
Okay, thank you. Are you seeing a psychiatrist or a therapist?
I was seeing a psychologist, and I have been released from seeing that psychologist, but I'm still in spiritual direction.
Do you think that has been helpful for you?
I do.
Have you learned anything about your mental state at the time the criminal conduct occurred?
I have.
What have you learned?
I've learned more so the defects in it. The sense of brokenness in me that inspired me, or that animated my wrong conduct.
Okay, be sure and keep your voice up. Do you regret your conduct?
I do, very much so.
Do you believe you've changed?
I do.
In what ways?
I think that I've become even more thoughtful, more desirous, doing good, more whole, even more reflective, even more aware of the great duty I have to be a force of good in general.
Are you asking this board to fully probate a suspension so that you can continue practicing law and serving your clients?
I am, please.
And is there anything else I've not asked you that you would like the board to know?
No, sir.
All right, pass the witness.
Ms. Cates?
And Mr. Keating, just a few things. You said that the office space that you were using during the time of your actions was also utilized by the victim's husband and the victim's father-in-law?
Yes, sir.
And I know you said that they weren't there very often, but did they have access to the bathroom that you were doing the recording in?
Yes, they did.
Did they ever use the bathroom that you were doing the recording in?
They probably did on some occasion.
But they never ended up on the video recordings that you possessed?
That's correct. I only engaged in that wrong conduct when Angela and I were alone in the office.
Okay, so are you saying that you would wait till everybody else was gone before you set up the video?
Yes, ma'am.
Okay. What is your relationship with the victim now?
I don't have one. I don't have one, and I am not allowed to have one. I'm not permitted to engage or have any contact with Angela, the victim.
Is that a forever circumstance, or is that solely a consequence of the probation?
That is a consequence of the probation.
Do you have any indication of trying to rebuild your friendship with the victim when your probation ends?
I would, I have this hope of being able to make amends for my wrong conduct. I don't know if Angela would want to engage with me. And my aim would be to respect her wishes. However, if she were to provide for an opportunity to work towards making amends with her, when I'm permitted to do so, I would do everything I could to make amends. But if she does not, my aim would be to respect her wishes.
How many clients are on your personal docket at this time?
Probably somewhere between 70 and 80 clients.
And in the event the board exercises its discretion to disbar you or put you on an active suspension during the pendency of your probation, would your business partners be able to handle your docket?
Yes, they would.
I don't have any other questions, thank you.
I have one question, Mr. Keating. Your criminal attorney, Mr. Schiffer, said that he thought Angela was a client or a former client, but I think I heard you testify that she was not a client. Could you just clarify that, please?
Yes, ma'am. So I represented, Angela worked for her husband's company, Caladad Builders. I represented at a point Caladad Builders, the company she worked for, and a number of business litigation issues. On an occasion, I represented her husband in a personal injury action. I represented her husband in that personal injury action commensurately with my criminal prosecution. We got an exception from the court to allow me to interact with Angela's husband during the pendency of the criminal proceeding, as one of the bond conditions was no contact with Angela or her family. So I only represented her husband's company and her husband, never Angela. I also represented Angela's father, a physician, in relationship to affairs related to his practice.
Thank
Thank you. Any other questions?
Yeah, when did you represent Angela's husband's business?
I represented that business in maybe 2017, something like that.
Okay, before the incidents at issue?
Yes.
Because these were in April, May, and June of 2020, correct?
Yes, ma'am.
Okay.
At that time, there was no attorney-client relationship between the business and myself.
Thank you.
Thank you.
I've heard some people describe the recording situation as a mirror, and some describe it as put a cell phone in the bathroom. And I'm curious because they reflect a different amount of premeditation to me. So I was curious if you could clear that up for me.
Certainly. In the restroom, there was a cabinet in front of the toilet that was open-faced. The recording device was placed in that cabinet.
Over how long a period of time did this recording go on?
About a year and a half.
And how many different recordings did you get?
About 400 or so.
Different people?
No, sir, only one, only of Angela.
How did you affect that? Oh, it was because y'all were the only ones in the building, you'd go in there ahead of her going to the restroom?
Yeah. Or just leave it in there, yes, ma'am.
Do you have an extra cell phone or something like that, that you would leave it in there?
I did, yes, ma'am.
Was a pre-sentence investigation done by the Harris County Community Supervisions?
Yes, sir.
Do you or your attorney have a copy of it?
My attorney, Paul Schiffer, does. I have a copy. I don't believe a copy of that was provided to Mr. West, but...
Do you have any objection to providing that to us?
No, sir, I don't. And if you'd like, I can also summarize it before providing it, as I had a chance to look over it as well.
If you have a copy here, I'd love to, if any of your attorneys have it, I'd love to have it provided.
Yes, sir. Mr. Schiffer left to go to another meeting, but I think we should be able to get that to you, provided there are no objections today.
I have not seen it, and I do not have it, but we can provide it to the board if you, Judge, if that's what you require.
Provide it today, great.
I'll do the best I can.
Any other questions?
Mr. Keating, how did these charges come to light? How did you get caught?
One day, Angela and I were in the office on June 6th, 2020, and Angela found the telephone. When she found the telephone, she left the office. She told me there was an emergency at one of the job sites, and she left. Subsequently, as I sought to leave the office, I collected my things, realized the recording device was not in the restroom any longer. I then received a call from my dad indicating that he and Sergio wanted to meet with me. We met, and I was confronted with my wrong conduct. I confessed to what I had done. Acknowledged its wrong nature and sought to make amends, sought to look for a route to attain peace and resolution. This was in June of 2020.
Thanks, sir.
Any further questions?
I have a follow-up question.
Okay.
You had testified earlier, I believe, that there was a portion of what was going on in you that you wanted to be caught. Is that right?
That's right.
Through counseling, were you relieved that you were finally caught?
I was. I was relieved that I was finally caught. Last night, for one of the first times in years, I slept with some peace in knowing that my wrong conduct will be, fully decided upon. felt immediately a sense of disgust with myself, a desire even to confess to my best friend, but I didn't have the courage to confess. I hoped to be caught to avoid having to confess, and knowing I could not keep that secret from her indefinitely. Through counseling and spiritual direction, I realized what I hoped for was an opportunity to be accepted despite my wrong conduct and affirmed, or disposed of as I thought perhaps should have occurred. And throughout the criminal proceeding, there was this unease, and now with this proceeding, my wrong conduct will be fully adjudicated on. I will have been fully judged for what I have done. And there's a great deal of peace in that.
Thank you. No further questions.
Thank you. You're excused.
Thank you.
Any further witnesses, Mr.
I have
West?
no further witnesses.
All right, we have exceeded our time that we allotted for this matter, so I'm going to dispense with closing arguments unless the board has any questions of either counsel.
I would like to just very briefly point out an issue if I could.
All right, you've got 3 minutes.
Thank you. Thank you so much for your ability to let me make this final point. Madam Chairman, in scouring the rules, 805, 806, 807, 808, there's nothing in here that prevents this board from exercising its discretion to put my client on a probated period of suspension. And that's what we're asking for, so that he could continue to represent his clients. He's made a definite turn in his life, and we feel that the best result for him would be to serve out whatever period the board feels is appropriate on a probated basis. Thank you.
Understood. Thank you. Thank you both for your arguments and your presentations in this case. The board will take it under advisement.